Hello, everybody in Brazil. I'm happy to be again at the Kudaip big conference. I started from the first lectures years ago. It was a small meeting. It has become so big, incredibly important in Latin America. Congratulations to Marco and to Angela as well for having me at the conference. My topic today, I changed to go to my slides as usual, will be the issue of AI law from an interesting perspective. I'm coming from Europe, and that means I'm coming from Germany, University of Münster, a famous institute called ITM. Um, And additionally, I've worked as a former judge at the Düsseldorf Higher Court, Region Court, which was specialized in copyright law. So copyright law is my favorite topic. If you want to give me remarks after the lecture, do not hesitate to answer questions or send me an email. What I want to talk about is what is happening in Europe in this moment. We have a lot of regulations just made several years ago. The Data Act, which is valid immediately for the whole of Europe. The AI Act, which is a complex masterpiece of legislation containing more than 400 pages of regulation. And we have brand new the idea of our head or president of the European Commission, Ms. von der Leyen, to present a digital omnibus package. I will explain what it is. The aim of all this legislation is to find a coherent governance for data, AI, and digital innovation. Let me explain you more about the acts. Most important is the Data Act, which entered into force in 2024. The objective is to establish a fair access to and use of data generated by connected devices. Key element is the user of these connected devices has a mandatory right to access to data from information and technology devices. Vice versa, the data holders are under an obligation to share this data with the user or a third person named by the user. Any IoT device must enable user access by default. And the question is, how does it function to have these complex new ideas in Europe when you regard the interconnection between Data Act and general data protection regulation and sectoral laws? Then we have the AI Act, which entered into force in August 2024. It has a very complex strategy for entering into force. It has a phased application step by step until 2027. The approach they use in the AI is different from GDPR, so from data protection, and the Data Act is a risk-based approach. So there's a classification of AI systems according to very, very dangerous AI systems, high-risk systems, and no-risk systems. And in the last minute, the Commission and the Council discovered there's a new trend to have GPIA, General Purpose AI, such as ChatGPT or Gemini. So, prohibited, for instance, is manipulative or predictive policing. The high-risk systems are the most important category. They are controlled by conformity assessment, by a variety of documentation duties, and by the need to have human oversight so that no human is simply controlled by high-risk systems. As I said, in the last minute, they integrated the rules for ChatGPT, for instance, transparency duties, and that's most astonishing. They remarked that GPIA is a matter of data mining, text mining exemptions in copyright law. So different from Brazil or Argentina, we have a provision, an exemption from mandatory copyright rights. That is, data mining and text mining is free. You don't need to pay for that. It's totally free. In that moment, court are deciding the matter is ChatGPT only a matter of data mining, or does a data mining exemption apply at all for the ChatGPT? High Court in England has just made several days ago a very important decision where it says on 200 pages that yes, it's data mining and therefore it's free. It's the same approach of the District Court of Hamburg, the court in Amsterdam, and the court in Budapest. We are very much in fear that the local people from Bavaria are crazy enough to contradict to that. We are awaiting harsh decision of the District Court of Munich, which might say that data mining exemptions do not apply to ChatGPT. So, nevertheless, the AI Act is based on fines, very high fines, 7% of the global turnover. That's a lot. And all the people are discussing what is the AI Act? Is it only public law, public supervision law, or is it a matter for civil law as well? We have a strange interplay between the Data Act and the AI Act. The Data Act governs access and sharing of data used for AI training. The AI Act has different approaches, requirements on data quality, transparency, and governance that leads to an overlap between the access rights foreseen in the Data Act and the documentation duties in the AI Act. So, for data-driven companies, that means they have to combine all the compliance changes of both acts, so they are in a very high-level regime of statutory regulation. So, that is the reason why the Commission will publish, I think, in several weeks, in the middle of November, the so-called Digital Omnibus package. It has nothing to do with the omnibus as a car. It's the idea to have second level of regulation laid over the Data Act and the AI Act. We need to simplify data regulation because it might kill as an instrument of overregulation the small flowers growing in the AI business. The Digital Omnibus package covers everything: GDPR, Data Act, AI Act, Open Data Directive, and so on. The idea of the Commission, which is quite good, I would have liked that they had this idea several months and years ago, is to reduce the burdens, especially on small and medium enterprises, clarify the overlaps between all these acts, and regulations, to extend compliance deadlines, because that is the biggest danger for killing new companies in the digital area. We don't know exactly what is in the regulation regulated in the Digital Omnibus package. So far, it is only known that the Omnibus package will change the whole structure of the GDPR. Data protection will change totally when the Omnibus package will come. The idea is to have the Data Act as a main regulation for data business, and to reduce the AI Act to the minimum. That's a totally different thinking compared to the situation before. However, that doesn't solve key questions like how will the Data Act in the future grant access rights, and how will this access rights affect AI training obligations? Will the Omnibus regulation lead to substantive AI Act amendments? Are small and medium enterprises sufficiently protected after the Omnibus package from regulatory overload? How do Data Act design obligations shape AI ecosystems? And what I said, I would have liked to regulate the issue of data mining and text mining exemptions in one of these regulations, as has been foreseen in the AI Act. So can copyright and AI regulation be structurally integrated rather than merely coexist in parallel worlds? So I think the Commission and the Parliament will step a step back, and only to jump 2 steps forward in order to have a new system, simplified, not over-regulated, for AI and data business. That marks a paradigm shift from exclusive intellectual property control towards access-oriented fairness principles. To mention that the Commission as well thinks about having a Digital Fairness Act separate from the Omnibus. So they are more interested in fairness principles and not in intellectual property rights. And this shift creates tensions, of course, between these old industries of these old white men forcing the national regulators to protect copyright law. We need to have a new world where nobody is talking anymore about this is my copyright, but we're talking about data sharing duties. That is most important. And what I like to mention that is Brazil. Because in Brazil, people like Marcos and even Angela are thinking about this global essays of information justice, access, innovation, and also rights must be reconciled through a shared ethical framework. I found in a very nice book in Brazil the famous sentence: "The future of copyright is not exclusion, get money, but integration, a system where human and artificial creativity coexist within fair data ecosystems. As I said, this I have found in discussing the matter with a lot of people from especially Brazil. So I hope that in the future, the old European model based on intellectual property rights as holistic model for getting money for industry is changed towards the Brazilian model, which is culturally inclusive, ethically funded, and focused on the digital fairness. We need to have a global ethics of information justice that balances access, innovation, and information rights. So I am very proud to have the chance to talk and discuss with my colleagues in the session about that matter and to discuss that matter as well with you. If you are interested, I've mentioned my email address. Send me your remarks. I would be happy, and I try really my very best to be in the future in Brazil and to meet Marcos and Angela. I wish the best success for your conference at the other 2 days.